WTIA is a nonprofit member trade association comprising over 1,000 member companies in Washington state, a not-for-profit nationally registered apprenticeship program, and a for-profit business services organization. Our mission is to build a robust, equity-centered technology sector that empowers thriving communities. The Seattle Metropolitan Chamber of Commerce is the largest and most diverse business association in the region and the designated associate development organization for King County. We have over 2,500 members across 13 different industries and seek an economically vibrant and globally competitive region where businesses of all sizes flourish and prosperity is shared. Before I turn things over to our moderator and panelists, let's kick off this webinar with 2 quick level-setting questions using the Zoom poll function to help our speakers get a better sense of how much this audience already knows about the My Health, My Data Act. Okay, I think we can stop and look at some results. Great. So I'm glad many of you are on this call. We look forward to helping raise some of your understanding of this legislation and provide some clarity on the scope and requirements of the law and how it might apply to each of your businesses. Before we get started, I will give a brief overview of the legislation. So the Washington State Legislature passed the My Health, My Data Act in 2023 in response to the changing landscape of data privacy and reproductive and gender-affirming care policy in the United States. It regulates the collection, sale, and processing of consumer health data. There are requirements that companies have specific data privacy policies, and the legislation also provides consumers with consent, deletion, and appeal rights related to their consumer health data. As you can imagine, our panelists will go pretty far in depth into each of these pieces. I will now pass it over to Sarah Clark, Director of Policy at the Seattle Chamber, to introduce our panel.
Thanks, Brittany. Hi, everyone. So first, I'd like to introduce our first speaker today, David Rice, who is a partner at Davis, Wright, Tremaine, and his specialty is in privacy and security compliance. And our second speaker for today is Todd Williams, who is a partner at a local law firm, Core Cronin, where he specializes in business litigation. Thank you, Todd and David, for joining us today. And David, I'm going to pass it over to you to kick us off with your presentation.
Thank you. So, are you able to see that slide there?
Yes.
Great. Okay. Thanks, everyone, for joining us today to talk about My Health, My Data. This is going to be in 2 parts. I'm going to be doing the compliance side, and Todd's going to take a look at some enforcement aspects. So My Health, My Data is an interesting law because the name suggests that this is something that only applies in the healthcare industry. Maybe it applies to hospitals, doctors, those, people in those fields. And in fact, it's really designed to cover information that's collected outside that context. So one of my takeaways I'm hoping for you to have today is really understanding how, even though you're not in the health business, this may have a lot of effect on you. So here's an overview of where we will be going, where my segment's going to be going. So we're going to talk about, what kind of data is covered under My Health, My Data. By the way, you'll see it as abbreviated as MHMD, sometimes MHDA, at any rate. So MHMD is how my abbreviation for it. So what kind of data is covered? Who must comply with the data with MHMD? Who is a protected consumer? Consumers are the ones who have rights under the law. There are some significant exceptions to MHMD, but the challenge is the significant compliance obligations that are associated with it. So we'll go through that, and then we'll talk a little bit about effective dates. So as was mentioned, this law was signed by Jay Inslee earlier this year, and it's supposed to cover, if you're familiar with HIPAA, the Federal Healthcare Protection Statute. This is supposed to deal with healthcare that falls outside it. The impetus for this was some healthcare concerns that arose after the Supreme Court's Dobbs decision. And I think there was a genuine concern that there was a lot of health information that people thought was protected by federal law under HIPAA, but in fact was not. Okay, so maybe, for example, if you have a Fitbit and it's collecting information about your heart rate, there's a good chance that's not protected by federal law. So that's sort of the context of it. So the basic elements of My Health, My Data are that there are going to be once we find out that we've got consumer health data, there are going to be some strict controls on how we collect it. So we're going to need to have some kind of express consent or a necessity to use it to provide a service that a consumer has requested. But that has to be in place before you collect consumer health data, and as you'll see, collect is broadly defined. There's some new disclosures. We're all familiar with privacy policies now. There's going to be a brand new privacy policy just for health data, as defined under MHMD. Consumers have new rights. They have the right to, know whether you're processing their data, they can access it. A lot of this is going to look a lot like what you may have heard that California is doing. A lot of these consumer rights, or what's been going on in Europe under the GDPR. So there are also restrictions on sales and sharing of personal information, and it's confusing as to what those things are. What is a sale? What is what am I sharing? And it's not necessarily intuitive, and the requirements for getting authorization around it are onerous. There's also something we'll learn about called a geofence, which is now prohibited. So I will save that until we get to the section. So kicking it off, what kind of data is covered by My Health, My Data? So, and I'll say this at the outset, since this is a new law, we don't have any enforcement history on it. Unfortunately, we have to go to the statute, and it's not a lot of fun to read statutes, so I try to break it up as much as possible, but it is important to know exactly what the statute says, but I'm going to try to summarize it as best I can. Well, consumer health data, which is the linchpin for all of this, is personal information that's linked to a consumer and identifies their health status. That's the easiest way to remember it. Well, what's that? What's health status? And there are actually 13 different specific categories that are provided for under the law, and here's some samples of them. And you'll find it is possible to interpret this in a way that's very broad. And I certainly don't advocate for a broad interpretation of this law. And I'm just trying to prepare people for the fact that some people may interpret it in a very broad manner. So, for example, one category is social, psychological, behavioral, and medical interventions. So if you're wondering what that means, that's an excellent question. We don't really know. It could be a whole bunch of things. And I have some examples on the next slide that maybe let us explore what some of this stuff might be. Information about bodily functions, data about bodily functions. How do we, what's that? If you, why is biometric data? That's one of the classifications of consumer health data. Why is that health information? So So it's not really intuitive. It's about you, biometric information, but that's not typically thought of as health data. Data that identifies someone seeking healthcare services. Again, it could be interpreted very broadly. Precise location information as it relates to your consumer health data. And the last one is health information extrapolated from non-health information. So what does all this mean? Okay, so I'm going to go to another slide and we'll talk a little bit about some examples of what that could be. Here are some things, and these are just questions. Like I don't have the answer. No one has the answer yet. But consider this. Let's say you buy, think about like you go to a supermarket, you buy some things that look like, they may indicate that you have diabetes or you're trying to lose weight. Is data about those purchases consumer health data? What about if you go online and you're doing some searches and your searches, you're looking for a yoga studio or some kind of other wellness information. You're looking for information about weight loss. Is data about those searches consumer health data? What if someone goes on to a social media platform and says, I'm just not feeling really good today. I'm kind of depressed. Work's got me down. Is that information consumer health data? What about somebody who goes to a hospital and you think, well, they're at a hospital, but so that must be protected under federal law because it's under HIPAA, because it's about patient information. But what if you're just visiting? What if you go to the gift shop at the hospital and you buy something? What if you're buying aspirin for yourself? What if you're buying it for someone else? So just kind of before you get to the last one, I think that there are you might find that some people will argue that data that I've just described is consumer health data and falls under this law. So there's no guarantee of it, but there are open questions around it. So the last one is sort of interesting, and I mentioned the last one on my slide is interesting. It's the one where you mentioned, you may recall from the prior slide, I said that consumer health data includes health data derived from non-health information. And you're thinking, what is that? That just sounds kind of, what would that really be? And in fact, what this was driven by a retailer's decision some time ago to evaluate purchases of non-health non-health related products and try to guess whether someone was pregnant. And these people were given a pregnancy score as opposed to determine whether or not they how likely it was that they were pregnant, and ads were served to these people. And so that's an example, if somebody buys a like a baby stroller, and then they buy a prenatal vitamins, or you can put it together and make some assumptions. So that's actually an example that was cited during the process of creating this statute as something data that people wanted to protect. So that shows you how broadly this could be interpreted. So that's the data. Let's talk about who needs to comply. Well, what the statute calls entities that are subject to the law, they call them regulated entities. So this is yet another thing that could be broadly interpreted. So it's anybody who's doing business in Washington or makes products targeted to people in Washington and decides basically how that data is going to be collected and used. So I've got the statutory language up here, but really that's the gist of it. Are you doing business in Washington? Are you targeting people in Washington? And you make the decisions about the data. So that can be pretty broad. I've got some examples we'll get to later of potentially who that could include, industries that are important to Washington. There is a category of entity covered by this law called a small business. And it actually, the only benefit of it is it gets you an extra 3 months in order to prepare to comply with the law. It doesn't really relieve you of compliance obligations, which sort of makes this different from a lot of the state privacy laws you may have heard about in, like, for example, California. So, all right, we covered the data. That is, the consumer health data. What is that? We've covered who has to comply with the law. Next, let's talk about who's protected. So the law refers to people who are protected as consumers. So who are they? Well, someone who's a Washington resident, but also anyone whose consumer health data is collected in Washington. Well, that opens the door for a great number of companies to be subject to the law that perhaps are not expecting it. And I will say this, there is one important exception, is that this law only applies to information in a household setting. It doesn't apply to employment-related health data, someone like health data related to an employee or anything that's related to some kind of business matter. It's really just consumers acting in their personal capacity. So we got, okay, so the consumer is the Washington resident or someone whose data is collected in Washington. Well, what does collected mean? Well, as you can see from the slide, it means doing just about anything at all with data. Okay, buy, rent, access, retain, just read the whole list. It's hard to think of doing anything with data that doesn't qualify as collecting. So that's one thing that's a bit confusing about this law, is it uses terms that don't really align with what someone's natural understanding of the word would be. Collect, usually, that's a pretty narrow category of to me, outside this law, that's really, narrow category of activity, but it's much broader than that. So again, it's unfortunate that we have to unpack all the statutory language, but it's really the only way to get to the bottom of how broad this is and why it's so broad. So let's then take a look at, what's the potential scope here? So let's look at some examples. So what about a regulated entity? This is who's covered by this law. So let's take a scenario. There's a company outside Washington, and maybe they're outside the US, and they collect or process consumer health data in Washington. Or they don't do it themselves on their own servers, but they have a company there that does it for them. That's called a processor, cloud provider, SaaS provider. And so question, again, these are questions, not answers. Are they subject to this law because this consumer health data is being processed in Washington? So, well, what happens if this person has no evident connection to Washington? There will be a lot of questions as to why someone in other regions are covered, why companies that have no connection with Washington are covered. So at any rate, just saying that could be interpreted that way. So, what is the impact of this on our cloud industry in Washington? We have, obviously, it's a critical part of our economy. And this new law has a potential to present some surprises. It won't necessarily apply in all situations, but it's something that I encourage people to think about if you're in that industry. Okay, well, that's how we've sort of like looked at who might be covered, sort of examples of, oh, what if you're in, outside the US? Well, what about, an individual who is not in Washington? So I have an example here. So this is a bit far-fetched, but who knows? So New York resident does an online search for weight loss information. The information is collected by a company's server in California. It's processed in Washington. So there's a cloud provider that's got consumer health data that's being stored in Washington. So what's does that apply there? Well, who does it apply to? Who are the entities? What do we call them? Who's the regulated entity? Who's the processor? Why, is it going to surprise people that a person's who's in New York their web search for health or for weight loss information all of a sudden is subject to this law, that might surprise some people. So overall, basically what we're left with is there are a lot of questions here. We don't have a lot of answers yet. There's no enforcement history on this because it's so new. If you're interested, the Washington AG's office has issued an FAQ on their perspective. But as Todd is going to talk about shortly, the way this is enforced is it's not just the Attorney General's office, but private plaintiffs can bring their own lawsuits. And are they going to agree with the AG's office on that? Probably not. So, I wanted to walk through some exceptions. These are going to look really, really technical. So I just think maybe the best way to here they are, but the best way to approach this is to think, first of all, it doesn't include anything covered by, federal health law like HIPAA, which you may have heard of. It doesn't include information covered by federal financial privacy laws, Fair Credit Reporting Act, student records, those sorts of things. Those are all, if you unpack the acronyms on there, that you'll get some of those concepts. But it also has an odd exception for publicly available information. So, well, what's that? It's not necessarily intuitive. So it's information that somebody makes available, that's made available through the government or on widely distributed media. Sounds like social media. We have reason to believe that the person who made it available, that was their intention to do it, and they had a lawful basis to do it. It gets a little bit tricky there because you're making some judgment calls. And what is widely distributed media? If you have a social media website where, not everybody can read all my posts, is that widely distributed? It's actually narrowly distributed, even though it's on a large platform. So that is an argument you may hear. So let's take a look at some of the compliance obligations. So remember, we've talked about what's the data, who's subject to it, and who's protected. So you probably, on your company website, you've already got a privacy policy. Maybe you've put it through the ringer so that it complies to EU privacy law, GDPR, California Consumer Privacy Act, maybe even Virginia and Colorado and all these other emerging state laws. So, you're going to have a new one, and it's a separate consumer health data privacy policy with a separate link, which the amount of clutter that is coming onto these websites with all these separate links that you're going to start seeing with, like, well, if you're a California resident, click here. There's another link for do not sell or, share my information. This is going to be yet more of that. So it's starting to get to a point where it can be pretty confusing to consumers. Nevertheless, this is the requirement. So you're going to need to get consent for collection of information, unless there's some kind of necessity that you have for using it to provide a service. When you do need to get consent, especially if you're dealing with things like sharing or selling data, which, as to what those are, can get a little confusing. They have to be separate consents. There will need to be extensive disclosures before you sell data. So quickly, selling data is when you provide it to a third party, either for financial gain, or you get something free in service, in exchange, like service. There's limited exceptions. If you get consent to sell data, it has to be time limited. It has to be signed. So there's some probably e-sign provisions that apply to that. But then the question arises: what does that do for targeted advertising? If I am sharing data about somebody with a third party so that they can serve ads while this individual moves from site to site around the internet. Is that a sale? Is that sharing? And if I do that, do I need to go through this whole consent process? And the answer is we don't know. So consumer rights, flag those a little bit. Not going to focus on them again, but there's more. So access restrictions. You need to have reasonable security requirements. Hopefully you've got those already. There are contract requirements. So if a covered regulated entity wants to take consumer health data and provide it to a third party, a vendor, to process it in some way, you have to have contract provisions added to the agreements. Basically, it says, hey, vendor, here are your instructions that you have to follow with when you process this data. And there's some limits on it, and you have to help us comply with these consumer requests when they come in about deleting data, because people can ask to delete their data. So MHMD has added an interesting prohibition against something called a geofence. So a geofence is a very specific thing. So a geofence is some kind of technology that puts a perimeter around a healthcare, a place where healthcare services are provided. And if there is such a, so basically you have 2,000-foot perimeter, and if someone is within that perimeter, you can't collect their data for the purpose of identifying them. You can't send them ads or notifications or things like that. So, and it's not something that people can consent to. It's just a flat prohibition. And I think that this was probably prompted by some concerns about people going to, abortion clinics and all of a sudden being served ads for things that they didn't, that they objected to. So, but here's where we are on this. So, one of the puzzles is, what's the impact of this really? So if I have let's say I've got a supermarket that has can tell where people are, and they or like maybe it's maybe it's some kind of like a loyalty card or something that enables me to know that when someone's shopping at the store, that they're buying these things, they're buying things for weight loss, they're buying something that's for their health in some way, and I want to send them ads, I want to send them a 10% off coupon. What does it do to that? It's we don't know. I give an example on this slide of something that's somewhat far-fetched, but who knows? So remember, covered entity has to be an entity that does business in Washington. So in my example, national pharmacy chain geofenced a Florida location. Remember, they do business in Washington, they're national, and the Florida location is visited by a Washington resident. Or maybe someone who is visited by someone in New York and their information is processed back in Washington. Does that apply here? Does that prohibition apply here? So, if I go into the pharmacy and, buy aspirin or something. So don't really know. We'll all learn this together. So one of the one issue that we're working through is making sure we understand the effective dates. This goes into effect in 3 stages. That geofencing prohibition that I just mentioned actually has already gone into effect. It went into effect in July. So, but most of the requirements for regulated entities, remember the larger ones, those will go into effect in March 31st. So it sounds like it's a long way. It's really not. So it's only 3 months away. And then the small businesses get to trail behind by about 3 months. So not very long. Enforcement, Todd's going to talk a little bit about that. It's private right of action. Injured individuals can bring their own claims under the Consumer Protection Act, and the AG can enforce. So again, I'm not going to cover that, but just wanted to let you know that's what's coming up. So at least on the compliance side, the takeaways that I want to leave you with are this just goes a lot farther than what anybody would have expected health data to be. And we have very broad definitions subject to a lot of interpretation. Maybe they won't be enforced in a very broad way. We just don't know. There are a lot of exceptions that you might find in other privacy laws, state privacy laws, or the GDPR that are not present here. And then there's the possibility of some very burdensome compliance obligations. So really what we encourage people to do is basically say, hey, does this apply to me? It doesn't sound like it at first take, but maybe a little bit deeper dive before you just rule it out. And I think some companies are going to find that they're subject to this law and just be a little bit surprised about it. We'll talk a little bit more about that during the discussion session. So next, I'll turn it over to Todd.
Great. Thanks very much, David. Appreciate it. Let me pull up my slides here. Okay, Sarah, can you see my my presenter slides?
Yes.
Great.
Looks great.
So I'm going to talk for a couple minutes about some things that we can expect in terms of enforcement and litigation following this law. The first thing I want to talk about is a frame of reference here. Some of you may have heard of the California Consumer Privacy Act. It's a law that was passed in mid-2020 in California. And it's a little more narrow than the MHMD in the sense that it applies to businesses which gross over $25 million and which share the personal information of over 100,000 or more California residents. And there's also a revenue threshold there. So it has some limitations that make it more narrow than the MHMD, but it also has a private right of action. And the California Consumer Privacy Act has a narrow private right of action for data breach and theft involving certain specific categories of data. And it allows the recovery of actual damages or $750 per incident. So in considering the potential effects of the My Health, My Data, I thought it's interesting to see what's happened with the California Consumer Privacy Act. And what I found is that in the little over 3 years since this has been in effect, there have been over 300 private lawsuits filed. So that equates to approximately 1 every 3 days. And I think this is a notable number, especially given the California Consumer Privacy Act's significantly narrowed parameters compared with the MHMD. Compared with other states, Washington is unique. Other states that have data privacy acts often do not include a private right of action, meaning an individual cannot bring a lawsuit on their own behalf to recover for damages due to violations of the act. So for example, in Colorado, Connecticut, Utah, Virginia, they all have privacy acts, but none of them have a private right of action. There may be other laws that allow similar types of actions, but no specific delegated private right of action. So Washington is unique in that respect with the MHMD. So here, the My Health, My Data Act has specific language making clear that there is a private right of action. And that private right of action is coterminous with the Attorney General's civil enforcement authority as well, which makes it somewhat unique and which leads to the conclusion that we're probably going to see a fair amount of private civil litigation involving this law, as well as enforcement from the Attorney General's office. And what the My Health, My Data Act says is that if you violate the My Health, My Data Act, you have what's called a per se Consumer Protection Act claim. Now, the Consumer Protection Act is a law that's used frequently in Washington in privacy violation cases. And the MHMD says essentially that if you can establish that you violated one of the provisions of the MHMD, you only need to show that you've also suffered damages and that those damages were caused by the violation. So again, looking at the California lawsuit numbers where there's a limited private right of action suggests that there will be quite a large number of private suits here. As David noted very appropriately, there's a number of areas where the statute is open to interpretation. And so we can expect that a lot of plaintiffs' firms out there will be looking to test the boundaries of these ambiguities. And until there is a body of decisional law interpreting the statute, or until there are amendments clarifying certain vague elements, I think there's going to be ample opportunity for private litigation in this realm. In particular, I think there's going to be significant litigation around what constitutes consumer health data, whether something can be reasonably linkable to physical or mental health status. I think there's going to be litigation around what constitutes publicly available information and whether the information falls into some sort of exception. And I think there's also going to be significant litigation around what damages are cognizable. We can talk a little bit about that in a minute. So, not just healthcare, but also I expect the sectors of consumer goods, exercise, nutrition, lots of different sectors are going to be affected simply because of the vast amount of data that's currently being collected out there. I mentioned earlier damages, and damages are important because the available damages often drives private litigation. It's the incentive to bring a litigation or not. And in this case, the MHMD allows a suit to be brought under the Consumer Protection Act. And the Consumer Protection Act provides for the following damages. It allows you to recover actual damages. It allows you to recover the costs of bringing the suit if you're successful. It allows you to recover a reasonable attorney's fee. And it allows you to recover either an increased award of $25,000 or 3 times the actual damages, whichever is lesser. In addition to that, if you are the Attorney General, you can receive restitution or a disgorgement of revenue derived from whatever acts were prohibited. So the big question for me going forward is, what are the actual damages that people are going to be able to recover? And for a sense of what those might be, we can turn to some of the previous litigation that's been filed in the privacy realm here in Washington. And there's a pair of class actions working their way through the courts right now that are somewhat analogous in the sense that they have allegations involving privacy violations based on an installation of a pixel tracking code in healthcare and pharmacy related web pages. And these complaints against Seattle Children's Hospital as well as Costco allege that the plaintiffs have been damaged because they have lost the value of their data and they have had an invasion of privacy. And this goes to the 2 main theories that I think we're going to see advanced in terms of the actual damages that people have suffered when there's a violation of the My Health, My Data Act. And the first is the loss of value of your data. And essentially, this theory is that your data has value and you lose the ability to monetize that data when a defendant collects or uses it without your consent. And these damages are typically measured with the price of its sale on the open market or through some sort of expert testimony to establish how much a person could reasonably expect to receive from that type of data. And then the second general theory is the loss of privacy. And that theory is you have an expectation and a right to privacy. And when someone violates that without your consent by using your data, your private data, without your consent, you've been harmed. And you should be compensated for this harm through an award of damages. Now, these certainly are not the only damages theories, but I think they're the most prevalent. And I think we will expect to see those going forward when people bring violations of the My Health, My Data Act under the Consumer Protection Act. I mentioned the Privacy Act earlier. It's a separate law that also provides a potential model for damages. It only applies to wrongfully intercepted communications, but it allows for damages of up to $100 per day with a maximum of $1,000. While it might not seem like a lot right off the bat, when you multiply that by a class size that's in the thousands or tens of thousands, those numbers can add up. And it's not hard to imagine a plaintiff's attorney pointing to this as a reasonable measure of damages for invasion of privacy under the My Health, My Data Act. We also expect that Privacy Act claims will be twinned in certain cases with Consumer Protection Act claims under the My Health, My Data. So I guess the bottom line takeaway is there's ample opportunity for litigation going forward, and we expect to see over the coming years some definition of the law, as well as a number of private suits. So what about enforcement by the Attorney General? Well, we can make some predictions, but that's really all they are. They're predictions. And they're based on a couple of data points. First of all, the My Health, My Data law was specifically requested by Attorney General Bob Ferguson, and he points that out on his website and in the FAQ pages. So we can expect that once this takes effect, the AG's office is going to similarly trumpet its enforcement of the new law, and we can expect a bit of focus on this. I expect a bit of focus also because the Attorney General's office has a pretty substantial consumer protection enforcement infrastructure that's already in place. They have quite a number of attorneys and investigators who are dedicated to this unit and who we interact with on a daily basis. So I expect that infrastructure is going to be put to good use once this law becomes effective. Although the AG's office has broad authority, typically their investigations are complaint driven. And so I think we can expect enforcement to be led by where they see complaints coming from. As some of you may know, we are likely to see a change in administration for the Attorney General in the coming year. We don't know exactly who the new Attorney General is going to be, but it's hard to see a big sea change in enforcement, regardless of who the new Attorney General is, just simply because of the investment in the infrastructure for the Consumer Protection Office that's been made so far. I think initially coming out of the gate, we'll probably see a focus on the most egregious cases with the most substantial impact. And then as the law gets refined and defined further, we'll see some follow-on cases from the Attorney General. Finally, before I turn it back over to Sarah and Brittany, one interesting aspect of this law is a codified reporting requirement by a legislative committee that's required to monitor the use and effects of the law. And to me, this shows that there is an interest in the legislature in fine-tuning the act if necessary. And it acknowledges the possibility that there may be some unintended consequences that need to be addressed either through amendment or otherwise in the act. So it'll be very interesting to review these annual reports that'll be issued for a sense of who's using the act, how they're using it, and whether it's being abused as well. And with that, I will conclude and happy to take any questions.
Thank you so much, Todd and David, for those incredibly detailed presentations. I feel like I've learned a lot, and I hope our audience members have as well. I'm going to ask a question here from the Q&A box. Mark Johnson is curious to know if there's any chance the legislature will try to fix the law or delay it, and I'm pretty sure we're thinking of in 2024.
I'll share my thoughts on that. I think that I haven't heard of any effort to fix or delay it. And I think I think it's going to be very unlikely. I don't know that it's regarded by legislators as being a problem. I think that they really wanted it to be very broad. My suspicion is that there was a lot of concern that if they made a law that was narrowly tailored, then companies would find a way to somehow skirt it. So they would prefer I suspect, to allow the law to take effect, see what happens, and then maybe down the road narrow it in some way if it's necessary. But I just don't see it happening right now. There are a lot of laws, like if you know anything about the Illinois BIPA law, it's Biometric Privacy Act, has all sorts of problems and concerns related to it because it attracts an incredible amount of litigation and surprises for companies who get sued under it with millions of dollars of damages. Well, that looks like it's right for a fix. They haven't fixed it. I don't think there's a lot of upside certainly at this point to for the legislature to fix it. This is considered an accomplishment by a number of members of the legislature. And remember, it's from the context of we're coming out of Dodd, we're seeing some concerns about health data. And I think those are legitimate concerns that they were trying to respond to. So at any rate, those are probably not very likely to get a fix anytime soon.
I certainly agree with that. I have not heard of anything or any movement of any weight to delay the impact or the commencement of this. And in fact, it's the opposite. I mean, all signs point to gearing up for enforcement and compliance with the law as scheduled.
Well, thanks for that great question, Mark. All right, and I've got a question. What industries do you think are most likely to be impacted? Or maybe some that we might be surprised about that may be caught off guard?
I would say industries involved in online targeted advertising are going to have to think about this. Well, that's a lot of companies, isn't it? Because, they're aware of these other state laws and they're aware of the European laws about what you need to do and with regard to certain personal data. But this is such an unusual, the name of the law sounds so specific to health data, but it goes much broader than that I feel like a lot of companies are going to think, yeah, we're not a hospital, we don't have to think about this. But in fact, there are some concerns if you are taking someone's personal information, using it to target ads to them as they go around the internet, reminding them when they're on another website that, hey, you left something in your cart when you were back on our site and when you were buying vitamins or something. So who knows if that's going to be actually something that gets, where there's enforcement around that or not, I don't know. But those are examples of the sort of unexpected consequences. Social media companies that are going to have to wonder about some of the issues I raised, whether or not something that is posted online qualifies as consumer health data. Is it a widely reported media? Does it fall under that exception? Or is it sort of a narrow posting that someone has made that's not supposed to be widely reported? So any company involved in sales of goods to consumers that all of a sudden, hey, wait a minute, maybe that's health related. So, and you think, I don't know, this is one I'm just thinking, you think about how, you want to talk about these inferences derived from non-health data. Well, what is a powerful new tool that people are using to derive inferences about individuals? Well, AI. AI is getting pushed into everything, and those are designed to create profiles of people in many cases. Some AI technologies, and you can use it to customize marketing to people, even if data that would fall under the definition of consumer health data is only a small part of the kind of data your company handles. How do you handle that? How do you weed it out from everything else when it's sort of vague to begin with as to what it is you're trying to weed out? So those would be my three industries, three focal points.
Me and Rose from our audience was wondering, would it also apply to medical providers who are reminding their patients to make appointments? Or is that HIPAA?
I think that's more likely to fall under HIPAA. Okay. But the question is a good one because this is really highlighting the fact that people are not going to know where the bright line is. And that's there's going to be a lot of puzzling over this, and we're not going to have answers for a long time without doing a very deep dive and then doing your best guess as to what based on what you find.
And we've got another question from an audience member, Jason, who says, I just want to make sure I understand this presentation and this law correctly. Is this law, this is the question. Is this law giving rights to all of this information back to the consumer-individual?
So if you are a consumer under the law and a regulated entity is collecting, again, that's a defined term, your consumer health data, then you have these rights, the rights to access the data that's collected about you, in some cases to have it deleted, to know who it's shared with. And yeah, so that's you have those rights. It's very similar to a lot of rights that consumers have in California already, and some other states, rights of access, rights of deletion. But they're coming to Washington. And one of the things that's come up is whether or not this is really, maybe thought of as in some ways as a national law, in the way that CCPA, the California Consumer Privacy Act, has national impact. With all the examples we were discussing, maybe it is something that is more thought of as a national law, and not really thought of as a health privacy law, but really as a more general privacy law. So just something to think about, with regard to that. But yeah, so basically you're going to start seeing people having rights that they would have had in other areas of the country.
Thank you. All right. And looks like we have a question from Stephanie in the audience, who asks, is a non-covered entity, i.e. a business associate, excluded under HIPAA? And the example says, if I'm collecting data that is generated from a doctor's office, is this excluded?
If you're a HIPAA business associate, I believe it's excluded under HIPAA.
Okay.
So I don't know if that answers your question. Can I ask Todd a question?
Yeah.
Certainly.
Okay. Let's say I go online and I do a search for the nearest yoga studio, and somebody takes that information and they use it to target ads for me. Like, how do you figure out what the damages are for something like that? Because I'll tell you, I don't really know, but someone's going to try to guess what it is, don't you think?
Absolutely. Yeah. I mean, the first way that comes to mind is, well, what would the price of that data fetch in the market, right? Like we all have data that's collected about us and sold out there, and there are marketplaces for all of this data. And so the easiest way to monetize that or to ascribe a value to that is checking that marketplace, I think. And separate from that, there are lots of experts out there who make a living off of attempting to ascribe a scientific value to this data. And they will conduct surveys of the general population to say, how much would you pay to prohibit this data from being shared? Or alternatively, how much would you pay to purchase this data so that you could use it for yourself, right, in your business? So I think that's the way we're going to see the value of this data leveraged in the litigation marketplace anyways.
Those experts are going to be very busy.
Yes.
Very busy. One thing that's interesting is the law has, I mean, I do think that there's going to be a lot of litigation that ultimately emerges out of this, but at least part of the law is already in effect. That's the geofencing piece. And we haven't seen any lawsuits yet. We haven't seen any enforcement around it yet. I don't know if everyone's just kind of just gearing up for March 31st when it goes into effect for large companies, when the most of the provisions go into effect, or I don't know. I would have thought that we might have seen something by now, and that's one puzzle I've got, because we're now, 5 months into that piece of it.
It would not shock me if there are already inquiries going out from the AG's office, right, to suspected entities. But I also suspect that they will be waiting for the broad enforcement to begin when the full effect of the law takes
Yeah.
effect.
All right, well, thank you both for this discussion today, for your presentations and answering our audience questions. Before we wrap things up, we want to ask our audience members the same poll questions that we started with to see how much you've learned during this webinar. So let's pause for a minute and see what the responses are.
Is this our grade basically now? What is your level of understanding? Hopefully everyone has a high level understanding. Don't mean to juice the poll, but
Hopefully it didn't go down.
It didn't, no,
Right.
yeah.
If you still have a low level of understanding, it's understandable. This thing's tricky.
Yeah.
So
Yeah. And all right. Just a reminder that since the event was recorded, the video will be available on both the WTIA website and the Seattle Metro Chamber websites very soon. And feel free to reach out to myself or Brittany if you have any additional questions. Thank you again to David and Todd for taking us through the nuts and bolts of the My Health, My Data Act. And we hope you enjoyed our program today. And for those in the audience, thank you for joining us. For more information, connections, and resources, sign up now for your Seattle Metro Chamber membership. And if you want to learn more about WTIA and become a member, please visit washingtontechnology.org. Thank you again and have a great holiday season, everyone.
Thank you. Take care.